This is the third lecture for M&A and PE. So far, we've been talking about only the M and the A aspect. But what about the PE aspect? Now, in a later lecture, we'll be talking about the different forms of investors that come to companies, or the different forms of investors that put in money into companies. These are called venture capital investors, or private equity investors, or hedge funds, or investment banks, and they're called by various names. Under the Indian legal parlance, they're all considered to be venture capital investors, or VCIs. Now, they could be foreign venture capital investors, they could be Indian venture capital investors. We'll come to that in a later lecture. But I want to take some time to understand and to discuss what is the difference between a share acquisition and a share issuance. A share acquisition is the purchase or transfer of shares from one shareholder to another, which means that whatever rights one shareholder had in a company are now being transferred to another shareholder. These shares have existed, they're part of the paid up share capital, and they're simply being transferred from one shareholder to another. However, a share issuance is a fresh issue of shares or a fresh subscription of shares by a new shareholder. Now, these shares did not exist beforehand. They were not part of the paid up share capital. In fact, they are being created or generated anew for the purposes of investment into the company. Now, shares are obviously transferred or issued against money. Now, the question is, who gets this money? So, if I, as an investor, if I am buying these shares from an existing shareholder, I would have to invest, I would have to transfer my money to this existing shareholder. On the other hand, if I am getting these shares issued to myself, or I'm subscribing to these shares, in which case I would have to pay the company. So when it comes to the PE, or the private equity aspect of M&A and PE, we're looking at transactions where the company passes a special resolution to increase its paid up share capital, and then it issues further capital under Section 62 combined with Section 42 of the Companies Act. This means that the company can raise funds by the issuances of equity shares. We'll be dealing with this in a lot more detail in the next few lectures. So let's now try to understand as to under what circumstances a company may need to issue fresh capital. A company may need to issue fresh capital for a wide variety of reasons. It could be to pay off existing loans or existing debt. It could be to expand its existing businesses into other arenas or diversification. It could be to increase its manufacturing or serviceability capabilities, right? So for example, if I have been producing 100 units of a particular good this year, if I get a new investor and I use that money, which I've received from the new investor, to buy more land and more plant and machinery and to hire more workers, then perhaps next year I could have 150 such units being manufactured, thus increasing my profitability. Now, primarily, companies will need money from time to time to grow, whether it's in the form of debt or it's in the form of issuances of equity, right? However, the decision as to a share acquisition or a share transfer is not left to the company as such and may not have anything to do with the company's growth plans. It has entirely to do with how the shareholder who's holding the shares and wants to sell them, how that shareholder feels about the company. Now, no matter what the reasons are, the shareholder, when it's selling its shares, it could be either a minority shareholder or a controlling shareholder. It's entirely up to the existing shareholder or the seller to decide when to sell their shares. Now, if the shares that are being sold as part of a share acquisition or share transfer, if they belong to a minority investor or a minority shareholder, there's not much change that happens when it comes to the day-to-day operations of the company or the core operations of the company. However, if the majority shareholder or the promoter in India, as it's called, if the majority shareholder decides to sell its shares, then we've got a larger issue on our hands. The larger issue being, why is the promoter or the controlling shareholder or the majority shareholder, why do they feel that this is no longer a good company for them to be in? Are there problems with the company? Are there issues where the promoter doesn't feel that this company is going to be profitable enough in the long run. So at that point of time, when lawyers have to be doubly diligent to ensure that there are no pitfalls when a majority shareholder is selling its shares. Of course, in a target company, when you do have a majority and minority shareholders, and the majority shareholder is selling out its shares, the minority shareholder will often have some rights to ensure that they are also given an exit opportunity at that same point of time. We call this tag-along rights, which we'll be dealing with much later in the course. So this was an explanation of the differences between a share issuance and a share transfer. In the next few classes, we'll be focusing more on share issuances and the forms of instruments that are typically used apart from plain vanilla equity shares when a company is raising funds.